Join former FBI senior forensic examiners Becky Passmore and Stacy Eldridge as they dig into the world of digital forensics, one bite at a time. Now leading their own consulting firms and educating the next generation of cyber sleuths, these badass babes of digital forensics bring sharp insight, real-world case experience, and a dose of humor to the bits and bytes that build today's investigations. From deep dives into business email compromise and ransomware attacks, Becky's specialty, to cracking the complexities of iPhone forensics, Stacy's obsession, this podcast delivers insider knowledge for professionals, students, and true crime techies alike. If you've ever wondered what really happens when the digital trail is all that's left, tune in and start parsing the truth.
Welcome back to Parsing the Truth, one bite at a time.
We are so glad to have you back as we talked about expert testimony at our last episode. And now we're really going to dig in and talk about a case where Stacy testified as an expert very first time. And the type of questions that she was asked, which were very interesting to me. And then how she was able to establish her credentials by testifying as an expert and really get into the jurors' reaction to her testimony. So, Stacy, let's kick this off with, why don't you tell us about what the charges were that were involved in this case?
Certainly. So this case is from when I was assigned to the Columbia Division in South Carolina, and this case was prosecuted down in the federal court in Charleston, South Carolina. And the charges against this defendant, there were 11 in total, but I'm going to give you the top ones as they related to digital forensics and the work that I did. So the first charge was taking a female coworker, employee A is how we're going to refer to her on this case, and he took her on a business trip across state lines to drug her, have sexual contact with her, photograph her disrobed, and thereby commit gross sexual imposition and voyeurism. And then accessing the computers of his former employer, pretending to be employee B, and then also threatening employee C. He also threatened employee A while pretending to be employee B. And then he went on to try to prevent the testimony of employee A in an official proceeding. So he's trying to prohibit her from testifying by riding a bicycle to the home of employee A while wearing a ski mask and armed with a loaded handgun.
Okay, you got me with this masked man on a bicycle with a handgun. Sounds like a Lifetime movie.
I think everyone involved would have preferred that it was a Lifetime movie instead. Now, the bicycle and the ski mask doesn't really relate to the digital forensics. I didn't do anything with it, but I thought that was just interesting and thought I would let everyone know about the fact that this happened in this case.
Wow. So what is the gist of what happened?
Basically, all of these crimes, the beginning of it all started back in March of 2005, and they executed the search warrant in July of 2006. So we're talking like 15 months, between 15 and 18 months later, depending on the different points of the timeline that they executed the search warrant. So some time certainly has gone by to when everything first starts with. And I'll kind of start at the beginning and talk you through kind of the background of the case. And then I'll talk you through some of the legwork I did to get started, just so everybody has that fundamental knowledge before we go into the testimony. And please, everyone, bear with me. This was 20 years ago. I am going off of the transcript. I do not have my notes nor my written report, nor can I remember things exactly from 20 years ago.
No, can't do that.
Okay, so basically it really starts off in April of 2006. There's a newish employee A, and she goes on a work sales trip with the defendant. and they're crossing multiple states to go on this sales trip. And during one of the stops, she's pumping gas, and the defendant goes in and gets the fountain drinks. After he's back, employee starts driving the car. She's also drinking her soda, as they call it down in South Carolina.
That's right.
Now, employee A gets so sick that they have to stop at a hotel. The defendant helps her into her hotel room. She's so sick, she doesn't even go on that sales call the next day. He comes back later to get her. And then, so that sales trip happens. And then in May 2006, the director of sales at this company receives an anonymous email accusing the defendant of sexual harassment. Company starts an investigation. The company interviews employees A, B, and C, who are all women, and they all concur that this sexual harassment has been going on. And then it gets weirder. At the end of May, the sales director gets an email supposedly from employee B stating that the sexual harassment charges are false. She made them all up and she retracts everything. But here's the thing, employee B didn't send that email retracting it. She didn't tell anybody to send it. And actually, when this email was sent, she was far away on vacation, nowhere near a computer. Then time goes by. We're a little bit into June, and the defendant tells employee C to go home for the day as she arrives. And I guess I should clarify that the defendant is in a manager position over employees A, B, and C. And so that's why it's not super unusual, but it is a little bit unusual for him to be like, employee C, go home for the day. And then employee C tells employee A to also goes home. But here's the thing, the defendant wanted employee A in the office, and he was trying to get her back into the office for whatever reason. But while employee A, the victim, is at home, she gets an email on her work email. They have laptops that, they're salespeople, they travel with them. And supposedly she gets this email from employee C while she is on the phone talking to employee C. So she stops and she opens it, and she is shocked to find 2 pictures of herself in that email.
Oh, no.
And she was even more shocked when she saw that she was unclothed and unconscious in a bed. And so they're like shocked and what is going on, because they're surprised and confused, and they're talking to each other while this came in, and employee C is like, I didn't do it. And so, they eventually get off the phone. Employee A reviews the properties of those files, those attachments, and she looks at the created dates of them. And that's when she sees that the created dates, the dates when these pictures were taken, was when she was on that work trip with the defendant back in April. And employee C didn't send it, and she never had any of those pictures. And eventually the defendant gets fired shortly after this happens. Now, remember, defendant is fired, not at this company, but now supposedly employee C is receiving a threatening email from employee B telling her that she has to tell the truth and resign from the company. And then employee B sends another threatening email from her work email to her own personal email, basically stating the same thing. So it's like, that's weird, right? She's threatening herself, or it's like a copy of it. It doesn't really make any sense.
Right.
Along with the rest of these things happening, like, who are these emails coming from? And then it goes on. So another email is sent, supposedly from employee C to employee B, but then employee B forwards that email on to employee A. And it's stating, there's more pictures like this, and you need to contact the one you have wronged. And so now he's got all three women involved with this, and it's making it, he's trying to make it look like, employees employees B and C are threatening each other and the victim and that sort of stuff. Eventually, they do the search warrant and all this stuff. He's released on bail, the defendant is. And then in January of 2007, this is when the defendant was riding a bicycle towards the house of employee A. And while he's wearing this ski mask and he's armed with a loaded handgun, and thankfully, concerned citizens saw this guy riding a bicycle in broad daylight wearing a ski mask. Now, you might be saying to yourself, well, it's January, it might be cold. Well, it's South Carolina. It's Charleston, South Carolina. It's certainly more temperate, but it doesn't get like really cold. We're not talking snow or freezing temperatures or anything like that. So it's certainly unusual to see a grown man riding a bicycle wearing a ski mask in broad daylight. So this person who saw it flagged down a cop, and the cop, luckily right place, right time. And he found the guy and then, did that bicycle stop and got him off the bicycle and, found the handgun. And then they found his car wasn't parked too far away. And they found some tabs of Rufinol in that car too. Lord knows only what would have happened if that person had not found a cop and said, there's this guy riding a bicycle wearing a ski mask.
Oh
and
my gosh.
Luckily also, the cop took it seriously and was like, I'm going to go look for this masked man on this bicycle riding around town right now.
Wow.
So it continues on that, in the opening statements, the AUSA clarifies that it was never employees A through C sending any of these sexual jokes that they talk about later on or any of these threatening emails, that it was the defendant. And one of the things they did before I testified was they established that the defendant had everyone's work usernames and passwords for all of their accounts at work. He had them fill out this form and stuff. So he had access to everything that they had. And they also found employee B's username and password on a piece of paper in his briefcase in his house. And that demonstrates that he still had at least her information after he was fired from the company. And one of the other interesting things, and I'm not in there for any of this, but I'm reading the transcripts now. The defense counsel stated in the opening argument that this had been a learning experience for me and about what computers can do and what they can't do. A technical marvel.
Interesting.
But he makes a point. He states, the key here is, and when you listen to the evidence, you must be mindful of who it is who has access to the computers in this case.
Interesting. Which I was also reading through these transcripts as we were preparing. And I also found it to be very interesting when your prosecutor introduced you in the court, as we were talking about last week. And we were talking about going through your education, going through your experience, going through your knowledge, going through your training. And then prosecution wants to enter you as an expert witness, and the judge allows the defense attorney then to ask you questions or to question based on your credentials. And I found it very interesting that the majority of his questions were, was this your first time testifying ever?
Yep.
In any
Yep.
case, federal or state, at this altitude, have you taken on such a massive case, and this is your first time to testify? And then his very next statement was, well, then good luck. And I thought that was interesting because that was in the transcript.
Right. So what was his strategy? Was he trying to make it really clear, like, I've never testified before, surely I'm not qualified to testify? Because one of the things, lawyers are going to do is attack you and your knowledge and experience. That's easy to attack, right? Well, I'm going to
Absolutely.
attack. And so by maybe making me say multiple times, have you testified? Because I was like, no, no, no. And then he's like, well, good luck. And I'm like, holy crap, what does he have in store for me?
That's right. And I always felt like it was the fear of the unknown as what they're going to ask you. But I always say that again, it goes back to those chess pieces and playing games when attorneys get up there, and it was more or less him trying to reduce your confidence level by saying, "Well, good luck." But he didn't need to. I mean, it didn't work. So, in terms of digital evidence, in terms of what you just described as far as this case goes, we're talking about in the terms of digital evidence. What I'm hearing is emails and pictures and what all is involved. And, a lot of times that sounds simple, but I'm going to say that there's way more law done than just reading emails and looking at pictures. Would you say, am I right on that?
Absolutely. 100% right on that.
Yeah, it sounds like you'll need to find evidence that um this defendant got the drugs, took these pictures, had the pictures, fraudulently sent the emails from the employee B to the employee C, and all the email accounts that were involved as well.
Exactly. That's the foundation.
How were you able to take all of this information, and how did you start working on the analysis and tying the pieces together of the puzzle?
In this case, I started with the known stuff. So in this case, it was the pictures and the emails. So we knew the contents of the emails, such as like the subjects, the wording, the body of the text in the emails. We also knew all the email addresses involved. And so I could keyword search for all of those sorts of things to try to find them. And then since a couple of pictures had been included in those emails, then I could hash those pictures and search for the matching hashes. There wasn't fuzzy hashing back then, so I had to search for the exact hashes, and that's all I was going to find. I wasn't going to find anything similar. So, like if he had modified something slightly, there was no chance of finding it. If the hash didn't match, I was out of luck.
Yeah. And so what evidence are you searching on?
In this case, I had 4 pieces of evidence, and I'm working off of the forensic images of 2 different laptops. There's a Power Pro and a Dell, and then 2 different thumb drives. It was a Sony and then I think a Fuji. I'll talk about it specifically later as we get into there as to what was on what. Now, obviously, camera was involved because he took pictures, and that was a Sony CyberShot camera, but I don't ever talk about or introduce anything specifically from that camera or an SD card. And I don't recall, was there nothing on it, or did we simply not get it?
Okay. So did you get any hits when you were doing your searches?
Yes, I did. Lots and lots of hits. And then once I had some idea about what the hits were, then I could start sort of going methodically through those different hits. And so in this case, I did start with the pictures. And since I had the hits on the pictures from the hashes, then I had some idea of where the pictures were. And because people tend to be at least somewhat organized on their computer, even if it's done for them automatically, the pictures tend to be at least like in your pictures folder. So, wherever it said in this case they were, then I went there and looked in that folder to see if there were any more pictures. And then, the keyword search hits for the different email addresses I'm going through and reading all of the different emails as well. Even though I did all this fancy keyword searching and hashing, at some point I did start to just use my eyeballs and review the pictures and, read the emails.
Right, because sometimes it's just about looking and reading, and then what did you do?
Since I had found all of this evidence that, the sort of the big thing that kicked everything off was the fact that those pictures of the victim were being sent via email, and all of those emails, I found evidence of all that sort of stuff. So now it's on to look for things related to the drugs, like the Rufinol.
Yep. And how did you know what to search for within the drugs?
So this is where I had a conversation with the case agent, as anyone should, whoever you're working for. I'm not a drug expert. They told me Rufinol, or do you say it Rohypnol? And the case agent and I even had disagreements about how to spell it. And she wanted me to search for it with one spelling, and then I was finding nothing. And then so I'm sure I just Googled the dictionary of how do I spell Rufinol, and then whatever spelling different one I used, I eventually did start finding hits for that. And they're going to give me any number of keywords to search for. And I think one of the things that's important to note is, yes, they are telling us what to search for, what the keywords are that they want, but that doesn't limit us. We can still use common sense to be like, I need to search a little bit outside of this. I need to maybe use some synonyms, especially when you're not finding anything. Like in this case, and I was like newer to this division. I hadn't worked a lot of cases with this case agent. So there was maybe a lot more going back and forth with her than if I had worked, a whole bunch of cases with her. Maybe I just would have been like, I'm just gonna, use whatever spelling I want. Because I didn't know, like, is there some reason we need to find it this certain spelling? And there was not. It was, I don't know if it was lost in translation or not, because later we find out, these drugs were purchased from Brazil. So I don't know if it was lost in translation between English and is it Portuguese in Brazil?
And I too have worked with many agents, is we are allowed to use our own judgment. And many times we know what combination of word searches that we can do, keyword searches. So, you're not restricted to what the case agent is telling you to search for. And quite honestly, people that are involved in drugs, just like you said, you had to look up how to spell it. They likely didn't search for it and spell it right the first time. So once you completed your exam and you wrapped it up by creating your digital forensics report that we talked about last week and your written report, then you went to court.
Well, we did have a little bit of trial prep in between, when I finished up those reports and then actually went to.
Yeah. So when you're preparing your exhibits, what types of exhibits are you and the prosecutor discussing is going to be introduced? Were you guys talking about it at that time?
Yeah, we did this as part of the trial prep. So this was probably a little further out where, we kind of talked about everything I found at a high level. And then he's like, okay, well, this is the type of stuff I want to show. And then I came back later and we had a variety of different things we used to show everything to the jury. And we used like some just printouts of the pictures, which I had to identify in advance and know which ones were. And in some of them, they brightened them up. And so they wanted, to show me, okay, here it is before it's brightened it. Here it is after we brightened it. Is it still the same, and getting to know all of the exhibit numbers. We also used some PowerPoint slides because there's a lot of information to go through. So we're showing a lot of stuff on the screen. And so again, whatever was in there, I was making sure that was all correct. And because this case involved chains of email strings where there's replies going back and forth and there's some forwards and stuff like that, with some of the emails, we did chop them up for the exhibit so we could just focus on what was the content of this one particular reply. And then we wanted to focus on the content of the next reply. So, it might be person X and then person Y. And we just wanted to have that be very clear instead of making the jurors scroll through pages and pages and gobbledygook to try to find the key thing that they needed to focus on, which was the words that were written. And then the other thing, because this does include sensitive material, you have to remember that the victim has been disrobed. So we're not going to sit there in open court and show over 100 pictures of her disrobed. So we did make a binder. And so I had to confirm all that stuff that was in the binder that was going to be handed out to the jurors.
So where does your testimony actually start after all this administrative stuff gets going, and then you get introduced as an expert, and then when and what you did when you received all this evidence? Like, so where does it all start?
Yeah, so I got up on the stand, I got admitted as an expert witness. Defense attorney wished me good luck, and
Good
then I
luck.
was on my way with the AUSA in this case asking me questions. And so we had prepped before, like we were talking about. It wasn't just the exhibits. We had talked about the line of questioning, and he was really good. I am so lucky I got him for my first attorney because he was very organized, and I had a really good outline of the questions he was going to ask. Certainly, it wasn't all word for word or anything like that, but it's like, this is kind of where we're going. This is the order we're going to go in. And this is the point. I'm trying to get this stuff in. So I knew where we were going, sort of the order. So I wasn't going to be up there totally lost, which has happened to me in other cases. I guess I got spoiled in this first one because in the other cases, I was like, I don't even know where you're going with this, as try as I might.
Right.
And so, but we actually, he has me start at a very fundamental level because let's remember this 2000s. So I literally started off by describing what a computer file is and the difference between user files and system files.
Very
And
fundamental.
yes. And then we're talking about file extensions. So .jpeg versus .doc, and if you can change them and what happens if you change them. And then we're talking about how deleted files work, how you can delete files, and the fact that they go to the recycle bin and you can restore them from this recycle bin. And that with my forensic tools, I can also recover files sometimes even after the recycle bin has been emptied. I even talk about recovering partial files, so just bits of files. And I mean,
And
we're covering it all.
Right. Are you looking at the jurors as you speak? And what is their reaction to this testimony? Are they understanding? Many times when we are testifying and we're looking at our jurors, we will get those head nods like they understand or they're following along. Were you getting that with these jurors?
Yeah, I think I was for the most part. Like anything, I think some people they're just non-expressive. They're just sitting there, and then there's some people sitting there feverishly taking notes the whole entire time. So you've got the range. You're kind of you want to look at them, make the eye contact so they know that you're speaking to them, and you're also looking at them to get their feedback. And I felt like they were tracking with me, especially at this beginning point. And then that's also why we have the exhibits later on. So, because I'm sure as I was introducing this, I was like employee A, an employee B, an employee C. And that's how they were referred to in the trial. So if you didn't have some sort of chart or visual, something to look at while I'm talking about all this stuff, you would be 100% lost very quickly. So again, another purpose for the exhibits is not just to get the evidence in, it's to easily track what is going on as I am trying to put the puzzle pieces together.
Right, right. Yeah. So all of this was just introductory?
Yeah, and I even had more introductory stuff, and I'll just kind of keep going here and wrap up like all the introductory stuff just so everybody has a foundation of this is the stuff I'm just talking about in general terms to lay the foundation for the actual evidence I'm going to talk about. I'm not talking about any evidence in any specifics yet.
So when do you talk about the evidence?
After I go through what drive free space is, after I talk about modified, accessed, and created dates,
Gosh.
and if I recover something that's been deleted and it's not in the recycle bin? Can that have any dates and times? I even talk about how people can access the internet and the browsers and how you get to websites. I talk about what an IP address is. I talk about instant messaging. I'm not sure why we talked about instant messaging because there wasn't any evidence involving that, but I don't know. Maybe you wanted to make sure people knew it was different than emails because I even talked about emails a lot, but I had to do some fundamental stuff. And that's where I talked about webmail versus a client, such as Outlook or something like that, and how saving emails work. And I talk about the fundamentals of email headers and the differences between forwards and replies and the fact that you can alter some of these emails.
Right. And so there's no talking about anything specific in any evidence. Again, how are the jurors responding? Are you having to provide analogies? Are you having to provide layman's terms to explain all of this information through the introduction?
Yeah, I'm laying out analogies as we go, and kind of like with the email, it was sort of like, the thing with the envelope, but then you could mail stuff back and forth, like the example of you get a bill and then you from like your electricity company, and then
Yes.
you cut like the part of it off and then you mail it back with
Mm-hmm.
your statement that you have to return, your coupon with your check, things like that. I did have to use an analogy when I was introducing like all the steps of what I did. And I guess this comes a little bit later. Maybe I can't remember where it laid exactly, but I did use what is now a very outdated analogy to discuss what a write blocker was.
Okay.
So I use the analogy of a VHS tape. So, how back then, if you didn't want to be able to record on it anymore, if you wanted to save it so you didn't accidentally record over your favorite movie that you
That's right.
recorded from channel 3, you put a piece of tape over it to write block it to prevent it from recording over. And so obviously great analogy 20 years ago, but if I said VHS tape today,
You would
I'm not
probably
sure.
lose a lot of people.
Yeah, I might
Yeah.
lose a lot of those people.
Yeah. Yeah. You would definitely lose a lot of those people. So then do you get to start talking about the evidence?
Yes, we finally start talking about the evidence with the emails, and we're starting off with the headers. So we're not even getting to content. We're just getting to like the fundamental stuff. What's in an email? And I explain how the way I read them is reading them from the bottom to the top to follow the path that it took. That's the order I always read it in. You could always, and it depends which email you have, but I mean, that's the order I always read it in. I don't know if you read it from top to bottom, and I'm always going from bottom to top so I can get back to the originating person's IP address. Excuse me. Yeah. So yeah, I need to, the whole point, you receive that email. I'm in this case looking for the sender's IP address of who
And
sent
so,
that email.
right. And so why is that IP address important?
It is important because you might be able to tie it back to the suspect. And so in this case, we were able to tie it back to the defendant.
And how were you able to do that?
So I had the IP address, and so I knew this is something we want to search against, get more information on. So I talked with the case agent, and then the case agent sent a subpoena out to the internet service provider of the suspect. Now, how much legwork did the internet server, or excuse me, how much legwork did the case agent have to do to find out where to send the subpoena? I don't know. That's their job. But, it's easier if you're in a small town versus a large town, right? Because then there's a limited number of providers.
Right, right.
And then so once they got the return back from the internet service provider, we reviewed the responses, and it's typically, this address with this billable customer, and they give the name and the address, had this IP on this date. Maybe it's, a date range, or maybe their IP address changes every day, but whatever. They give us all the logs and we go through that and see if it matches. And so in this case, the sender of this email, and this is one of the threatening emails supposedly from employee B or employee C, is coming from the defendant's home IP address.
Right. And this helps ties that email that was sent to the defendant then, right?
Yes. And so on this date and time when it was sent, the ISP confirmed that the IP address was assigned to the defendant. And it was really helpful for our case to at least get it tied to his address. But it's not the end of tying the email to the evidence. We just didn't present this IP address and be like, okay, case closed. He did it. It was only the beginning of what we were trying to lay out here.
Okay, so anything else good in the email header?
Yeah, there was the authenticated user that was logged, which in this case was the defendant's personal email user account.
Yeah. And then what happens next?
Now, at this point, I start to share with the jury what the case agent asked me to look for. And then I basically discussed everything I shared with you all earlier about how I started off my analysis with the knowns. And I kind of walked them through everything I did and looked for at a high level.
Yeah, I think this is a really good stopping point for us. We've explained a little bit about the case. We've talked a little bit about what was expected of you and the testimony. So we're going to stop here and come back on our next episode and really dig into the evidence and the exhibits and the testimony. Until then, stay safe, stay sharp, and as always, keep parsing the truth one bite at a time.
If you've enjoyed this episode of Parsing the Truth One Bite at a Time, please head on over to our website, parsingthetruth.com, and click on that donate button and help us raise funds to send one future digital forensic examiner to the IASIS Basic Forensic Examiner Training next spring in Orlando.